It's been a rough, a bit long, bumpy ride, but I just want to start by giving all of us encouragement to say that we have had a lot, we have said a lot, and surely we have learned a lot. And the part that we are going to deal with mainly tonight is a wrap-up of the pre-trial proceedings that we've been mainly dealing with. And as you are well aware, tomorrow evening will be our last evening. So, like I did say that I wasn't really particularly concerned about us finishing up. I just want to assure everyone that for the slides that have been shared with you, I am quite confident that we will get to them. So the same way we've been flowing with the classes, I would plead that we continue in the same fashion, and let us ensure that our questions really do not take us back and forth to a point where we even end up confusing ourselves. So I'm not, like I said, I'm very much welcoming to inputs, questions, or whatever that clarity seeking that you may have. But I just want to ask that really we mustn't, let's try and listen. Like I did say, I start with the slide, I go through the slide. When I'm done, before you come with your questions, make sure that really you're not just making me to end up repeating myself, because that eats up a lot of our time. So I don't know, Ma Hlahonolo, your hand is up. Do you want to ask something, or you are testing your device? Okay. As I said, I don't really pay attention to the hands that are risen. If you would like to say something, it's best that you speak up. So I take it that maybe it's some testing that the person is doing. So if you have anything to say, then please speak up, and let us try, ladies and gentlemen, as we agreed when we get in to join the class, as advised, we must have all our mics on, but immediately you are in the session, please mute, because we don't want those terrible sounds that are coming. And please keep also your videos off, as you know, we don't want to see any indecencies on anybody's part. So, ladies and gentlemen, we are...
Hello.
Yes.
Good evening to you.
Good evening.
Just want either today or tomorrow. I did a bit of research or reading yesterday after you spoke about the charges, and
Yes.
that's a case which may interest us, FICA versus S, and it's to do with where the court found spoke about dominus litis, where the prosecutor has solely the decision that or the charges are solely based on the prosecutor's discretion. Now, this case deals with a plea bargain that was made between the accused and the defense and the prosecution in a murder case, where the prosecution they had a plea bargain, and she was charged with culpable homicide. The magistrate during the case, or I think during the bail appearance, insisted that she be charged with murder. So it went to the appeal court, and they found, or during the judgment, they found that the magistrate erred by changing the charge from culpable homicide to murder. So if you could just maybe you already know about it, but later if you go through the case, just give us a brief understanding on that special case, if possible.
No, honestly, I don't know about it.
Okay.
I don't know about it. And also I have to state that, ladies and gentlemen, I'm like I've stated, I'm fully employed. So when I finish at work, I rush to just start the classes with you. And if I find that maybe there is an issue that I needed to do a lot of research on, then it would mean I would maybe do that during my lunchtime and then have enough time to address it here in the session. But because when I thought about our class yesterday, when we spoke about the difference between the alternative and the competent verdict, I was certain that it was made clear which offenses would then make one to be found guilty of an alternative and which ones would one be found guilty of a competent verdict. And I did say that the alternative will be stated clearly when the main charge is read out. It will be mentioned as well when the charges are put before the accused pleads. So the competent verdict, I think one of our colleagues did mention that the court would also even pass that warning to say, even though there's only one main charge that is appearing, should the evidence prove that that main charge cannot be proven, but however, there's elements of a competent verdict which are found to exist, there is that possibility that the court can find the accused guilty on a competent verdict. So that one, it's the one that would be pronounced by the court when it is giving its own judgment and after it has done the analysis of the evidence. So I don't know what else I can say on that. And on the case, what maybe I would ask Mr. Naidu that you can do to enlighten us, you can maybe share that citation in the comment section so that we can all have time, even after this, maybe over the weekend, to read up on the entire case, if it's going to help us to have more understanding on this topic. So I will appreciate it if you can type out that full citation of that case in the comments.
It's fine. I understand your circumstances, but it's just it's FICA versus S, PHIKA versus S. We can Google it, and it's a very interesting case that took place. So
yeah, that is why I'm saying, especially because you say it's of interest. Definitely, I'm also interested. So please, because we are gonna move now and we're gonna talk about a lot of things. So the comments are there. Even when the sessions are off, we can just quickly go and check it as you have written it in the comments. That's why I was asking you to just type it in there so that we can have time to have a look at it.
no, I understand, madam.
Thank you so much. Yeah.
MC.
Yes.
My slot is still on at number 22 of 41, has never changed.
That is where we are, Minir. All of us were there.
Oh, and then with this competent verdict, just to summarize it in 1 minute, I think is that the court cannot charge somebody like the court cannot charge somebody with murder and as well as with assault common, because those assault common is also included in murder. So assault common is a competent verdict of murder.
Yes.
Like also robbery, the court cannot charge a person robbery and then charge also for theft.
Yes,
because already theft is already included in robbery. You see, that's what they mean about competent verdicts.
Yes, and it was made clear that the competent or the alternative will be the less is the most.
The alternative, the different one. The different one, like if a person is charged with murder, then maybe also he will be charged with I don't know whether it may be rape, but it will be a different one. Not that the charges were it's like now splitting the charges for a competent verdict. The court cannot split the charges which are similar. You see, charging me with murder as well as charging me with assault common, because assault common is already inside the murder. Robbery, theft is already inside the murder. I mean the robbery.
Agreed, agreed. Yes, we agree. So before I forget, please let's also have someone to make us aware when we knock 19:30 so that we can take our break, 10 minutes break at 7:30. Please, ladies and gentlemen. So today we are now moving from the methods of securing the attendance. We are moving to the methods of securing now the release of the accused person. And here we are talking about the main method of doing so is a bail application. Now, the purpose of a bail is to secure the attendance of the accused to court. And the aim is to minimize the impact on the accused freedom at a stage when they have not yet been convicted. And the general principle is that the accused is then entitled to be released on bail at any stage before conviction, based on the presumption of innocent until proven guilty. So the court should be satisfied that before it grants bail, that the interests of justice permit the release of the accused on bail. And always, ladies and gentlemen, bail applications are going to be treated on an urgent basis. So what this means is that when you have a court roll that consists of different cases, when there is a bail application, it will most likely be given preference, or therefore it means that it will be heard before, say, for example, if there's also trials on the roll on that day, bails will be entertained before the hearing of those trials. And we are also having situations where if you may wish to approach the courts on an urgent basis, that is, for instance, where if you had started in the lower courts to apply for bail and your application for bail has been refused in the lower court, you can proceed on an urgent basis to the High Court. So it should not be taken for granted that even the judges will move everything aside in order for them to entertain the issue of bail. Now, in the matter that is mentioned here of Stattenheim versus Mashia, the magistrate in this case had postponed the matter for 8 days after hearing the evidence of a bail application. So they had evidence, but instead of this magistrate granting, giving their judgment on this bail application, the court allowed the matter to be postponed for a further 8 days before the outcome of the bail application could be pronounced. Now, an order was sought by the defense to compel the magistrate to hear arguments and to give judgment on the same day. So the order was then granted and requested. However, the magistrate, after he heard the arguments, he postponed the matter for a further +5 again, 5 days again for judgment. Now again, the defense brought another urgent application, this time before the full bench of the High Court, for the release of his client on bail, and the magistrate was held in contempt of court for not complying with an earlier court order that had indicated that the matter or rather the bail application judgment should be given. And on that basis, then the High Court actually went on to grant the accused in that matter bail, ignoring what had been done by the lower court magistrate. So, ladies and gentlemen, why I mentioned this case, it's particularly focused on the magistrate. What you will find in practice, and I've seen this in many of the district courts, even in the regional courts as well, that when a case has come before the court for first appearance, as I already discussed, that most of those cases are still undergoing investigations. So the state would then say they are still doing the investigations. Then that's when the defense lawyer would then ask the court to entertain the issue of bail. Now, at those courts, in many instances, especially where the court is being told by the state prosecutors that they intend maybe to oppose bail, they will then say, because their investigations are still ongoing, they will then ask the court to have the matter postponed in order for them to can prepare themselves for the bail application to be heard. So the reasons for those requests for postponements, they will say, for instance, they still need to verify maybe the address of the accused, or they still need to check on the legality status of an accused who is suspected to be an illegal immigrant, and maybe any other factor, ladies and gentlemen, will be stated why they are asking for the matter not to proceed on that particular day. And they will then ask the court to grant them at least 7 days postponement in order for them to do all that they need to do to prepare for this bail application. Now, when you check in the Civil Procedure Act, the Criminal Procedure Act, you will find that they do actually make reference to the provisions of the Criminal Procedure Act, where it is mentioned that the state can be granted postponements that can be up to 7 days for them to prepare for this bail application. So please take time and ensure that you read again that particular section concerning this so-called 7 days rule. Now, what you need to watch out there for, it's the wording of that section. It says that they may be given up to, that's my focus on this discussion. It then leaves room to say that the postponement then need not necessarily be a complete 7 days before the matter can be brought for bail application. It means that the matter can be maybe postponed for a day or two earlier than that entire 7 days. So what you would then do as the defense lawyer, if faced with a situation where the state is standing that they are entitled to take up to 7 days to prepare themselves for the bail application, then you need to get to the understanding of the actual reasons why they would want to take a whole 7 days before they can do this. So in most courts also, I believe that it's a common practice. Obviously, the court would ask, especially when the defense is also asking the court to consider a shorter postponement. And for instance, a case where the police are saying they still need to verify an address. I know of instances where, like I said, remember the charge sheet that we spoke about, the front part of the J7, where the names of the accused are already mentioned. I did say that it's also going to, most of the time, there are instances where they will say the address is unknown, but in most of the cases, there will be not only the name of the accused, but also an address of the accused that is already reflected on the charge sheet. And also, ladies and gentlemen, remember before this person was brought to court, the state would have worked around that 48 hours. So it's possible that the accused could have been at least, held in detention cells for at least 24 hours or a little bit more. So if the address that the accused has given to the court is falling under the jurisdiction of the court, and it may actually be 2 or 3, not too far actually, from the court building, I think then it's upon you as the attorney then to highlight the fact that it wouldn't need 7 days for the police to get to that address if the location is not too far, that they would just need to verify that. Sometimes the courts also take it upon themselves, whether you would agree that it's procedural for them to do so or not. I mean, that's an issue for debate, but I have seen where the courts will ask from the people who are present in court, and they will ask from the podium, is there anyone who is a family member attending on behalf of that accused? So, sorry, ladies and gentlemen, then if it's a matter of just verifying that address and the place is not too far, then you can make maybe a suggestion to say, maybe the matter can stand down and the investigating officer can maybe book out the accused if maybe they will say they are not sure exactly of the location, for them to go with the police to actually point out their place of residence, because sometimes the police will come back and say, we went to the premises, but we found that the house was locked and maybe we couldn't confirm exactly maybe the house number, especially with people who are still staying in informal settlements. House numbers will be an issue also. There's no visible street names. So whatever that you can do on your part to help to speed up the process of confirming some of these things that the state may want, whatever the state may want to confirm to the court, then you can also assist and bring forward information. Now, if there's a family member, the court will ask that person who's in court maybe to come forward, and they may even take a stand, and they will be made to take oath, and then the court can question them. What is your relationship with the accused? And if maybe it's a parent, they will say, the accused is my son. And they will then ask, who does the accused live with? The accused stays with me. Madam, what is your address? They will mention probably the same address that is written on the charge sheet. And sometimes the court would then ask the state, do you still have issues, that you want to probe further regarding such an issue of an address? And if they don't have further objections, you may actually find that the bail can be entertained on the same day. Or if they still maybe want to assure themselves by going there, then you then say the witness, it's a court witness, whoever is the parent or a family member, then they can accompany the investigating officer to point out and maybe bring out some documents also to verify that the house belongs to them. And if that can be done, just to speed up the process. That's the point I'm making. So please do not assume that every matter should be postponed for 7 days. It is possible that it can be less than that, and obviously try as much as possible to bring up your own efforts to push that confirmations that they need to do and verify whatever that needs to be verified. Okay. So I also say that bail is entirely non-penal in character, and therefore the refusal of bail should not be used as a punishment, nor can a court fix an excessive amount of bail, nor erroneous conditions of bail in a bid to harass the accused. So what we are saying here is that the amount that the court will fix, the court needs to first, before it decides on a suitable amount to fix for bail, an inquiry must be made into the affordability of that accused, whether they will be in a position to raise funds to pay that bail application. Because if the court is going to say bail is granted, but the amount that is fixed is too excessive, it's outside the reach of this accused, they will not be able to afford it, then it's tantamount to the court actually refusing bail. So yes, there are situations where you may plead with the court for a reduction of bail, but then that's also another application, you know, on top of that main application for bail that you would have done. So before the court pronounces the amount that it's fixing for bail, a clear consideration should be a proper consideration of the affordability of the accused, also taking into account, of course, the type of offense that the accused is charged with. So the court will then have to decide on that. Now, when we are talking about ordinance conditions of bail, it happens also that after the court has fixed an amount that, okay, we assume it's something that the accused is going to be able to pay. Now the court, through you, the defense, you can also make the request for the court to impose conditions for the bail to assure the court that if the court is considering granting the accused bail, the accused is also willing to go an extra mile to show their, willingness to cooperate with the courts, and also even willing to subject themselves to a court imposing what is called bail conditions. Now, those bail conditions, they cannot be something that the accused is going to find difficult in order for them to abide with. Often also in practice, and this one is common a lot, that a matter will also, after the court has fixed bail and the accused has already paid the amount of bail, so it's already out on bail. Now the defense lawyer will come and ask the court to relax those bail conditions that were agreed upon. So when you're asking the court to relax the bail conditions, in most instances, obviously you need to say why should the court change the conditions that had already been, because the court, when it granted the initial bail, it would have stated the conditions, and the accused wouldn't have immediately objected to those conditions. He would have said, as the court pleases, then I will abide. But now you are coming back now to say that the accused is not able to abide with the conditions. So what I want to say here is, I understand that maybe the situation of you wanting to get bail for the client may be, pressing, because you just want to secure the release of your client. But make sure that when you are addressing the issue of conditions being placed on the accused, ensure that they will be able to abide by them. Many times the lawyers come back and they will come and say the court must relax, and it is quite irritating to the presiding officers, because now you will be saying the accused is working, they can't be coming to report to the nearest police station two times in a day because they are staying, for instance, in Johannesburg and they are working in Pretoria. This makes them to be delayed and held up in traffic, and always makes them to arrive at work late, which means that now they are possibly going to even lose their job. So now this is something that you should have considered earlier when you were being informed of these conditions, because you should have known that if the court says report 2 times a day, then you need to check with, don't just say as the court pleases, consult with the client and say, will it be possible for you to go to the police station in the morning, in the evenings, before you agree?
I'll see.
Yes.
When doing the bail application, is hearsay evidence allowed?
Yes.
Okay.
That is automatically the exception when it comes to one of the exceptions. If you check law of evidence, section 4 of law of evidence, that's what the one that deals with the admissibility of evidence. One of those conditions is that hearsay evidence here of a bail application, it will be, for instance, where an investigating officer, remember, he was not present at the scene of the crime, they come to testify based on the information they have collected about the case from hearing the stories from the witnesses. And then they come to court to put the court in the somehow a bigger picture of what the case is all about. So that investigating officer is going to give the court hearsay evidence because they were not an eyewitness to the incident. They were not actual victims, but the court will allow for them to testify because the court needs to have information about the allegations that the accused is facing, and not only to just hear what I'm telling you now here. I'm going to go a lot into the personal circumstances of the accused, but also before the court decides to grant bail, it will want to know more about the charges, how serious, what type of evidence they will have against this person, in order for them to can do what we said in the previous slide and make sure that it will be in the interest of justice to either grant or refuse bail. So the next case there is State versus Atchison. And in this case, it was held that an accused person cannot be held in detention pending his trial as a form of an anticipatory punishment. And the presumption of law is that the accused is innocent until is proven guilty. So here we are looking at situations where the court will put a little too much emphasis on the seriousness of the charges, because the more serious the charge, the court can anticipate, because of things like minimum sentences, that this type of charge, if the accused is convicted, they are likely to be given a very tough sentence. So even if, yes, the charge is what is called a very serious charge, and we anticipate, because of the nature of the charge, that the sentence will be harsh, we are not going to assume that the state will prove its case. The trial must still go on, evidence must still be brought and tested, and the accused then will obviously have his own opportunity to answer to the charges. So a whole assessment of the whole entire case will be done. You cannot sort of like prejudge that I'm likely to give you a very stiff sentence if I convict you, and because of that, I can't risk with granting bail. That is basically what is being said on that case.
Yes, please, can I interrupt you, please?
Okay.
Yeah, please, ma'am. I've been hearing you saying words like sitting the case down and standing the case down. What
Mm.
is the difference between sitting the case, setting the case, and standing the case down?
No, that is just let's say, for instance, the case is enrolled to be heard on that day. It's on the appearances for that day. Say, for example, the court is coming to hear the bail application, or rather, yes, the matter is, say, for example, the first appearance. It's today. Now, at that first appearance, the court would want to know, is the accused going to apply for bail after they've been informed of the charges? If it's something that they would want the court to consider, because the release after the rights, it's obviously the next question. State, what is your attitude about bail? Are you opposing? Are you not opposing bail? Then if the state says, we are not able to address the court at this stage because we have those, for example, the issues of us still checking on the address that the accused has given to the police, so that when we go into the bail application, the state will be certain that the address provided to the police is where the accused is ordinarily resident. So now the case is in court. Already this debate is happening in court. Now you have in your mind a way of helping to fast track that address to be verified. And you don't want to go into a debate in front of the presiding officer about this. You will then maybe ask the court that, before you talk to the prosecutor, that, look, maybe someone is here, maybe the mother of the accused is present here in court with her ID, maybe birth certificate of the accused, and also maybe their municipal rates statement to prove that they own that address that the accused has provided. You know that you can verify it right there and then. You then say, you ask the court, can the matter stand down, so that you can liaise with the prosecutor with regards to what you want to give to them to check. Or if you would want to say the accused must be booked out so the investigating officer can take them there, you can address it with the court. And if the court agrees that, okay, the investigating officer is present in court, they can do that, then it will then either be yourself or the prosecutor who will then ask the matter to stand down. It doesn't mean it's postponed. It's just being put in abeyance for you to attend to whatever you need to do or to check upon. And then you come back on the same day to later either proceed with the bail application, or if they couldn't verify what they wanted to verify, then it will call for the matter to be postponed to a future date.
Stand down here, does it indicate they should give you some few minutes?
Yeah. You can ask for a few minutes, few hours, or you can even ask for the matter to be rolled maybe to the following day, so that it also forms part of the cases that are set down for the next day.
Okay.
Yeah. So those are just words. Yeah.
Yeah, because we need to understand them.
I understand. That's why I explained. Yes.
Just a quick one. Is standing down the same as adjournment, or is there a difference?
Yes, it's the same thing, because when the court can say the matter stand down. So when the court says this matter stand down, the court is not taking a break. I don't want to use your words that you just said. So when the matter is standing down, it means they're just putting this matter on the side. They are proceeding to call other cases that are on the roll. Now, when so when they adjourn the court, they can adjourn for a bit, maybe for tea breaks, or they adjourn maybe for lunch. It's just words, ladies and gentlemen. But also, even at the end of the day, the court, when it's done for the day, the court will, the presiding officer will say, court adjourns. Then you know for that day, They're done. Somebody's talking. Nhlakanipho, please mute. Please mute. So if the court is done for the day, they can use that word, court is adjourned. It means for the day now, the court is not coming until tomorrow. So it can mean the court is just taking a few minutes break, and they can even say the court is adjourning, we are taking a tea break or we are taking a lunch break. And even at the end of the day now, you would see that there's the court books have been closed. There's no other cases that are coming on that day. Then court is adjourned for the day. For the day, it means we are coming back maybe tomorrow.
Ma'am, just to add on that, today I was in court. One of the matter was put to stand down because of some of the witnesses were late for the court. So
Yes.
while we were waiting, then the magistrate decided to put the matter on standing while we're waiting for the witness. So it is maybe can be put on stand due to the lack of information for the court to proceed.
Sometimes it may be even you, maybe there's some aspects that you want to discuss with your client, and you don't want to take the court's time while the court is in session. You are busy there standing, the accused is in the dock, you are busy, everyone is watching you. You can ask, your worship, may this matter stand down so that I can have an opportunity to properly consult. Then they will then give you that indulgence to put it aside. Then that is basically for just that's that. Okay. It's not a technical thing. It's just for convenience. When you see that, or maybe sometimes you are in the middle of your leading, or rather you're cross-examining, and maybe there's an issue that you want to check up, maybe on your notes or whatever, and you can't find something, and you see that you'll be delaying to ask the court to wait for you. You can ask a few minutes, or maybe you want to go to the bathroom. Nature is calling, you see, and it's not yet tea break, it's not yet lunchtime. You can then ask for the matter to, the court to take a brief break so that you can adjourn and address whatever housekeeping that is done in the court on that day between yourselves and the state. That's just a thing. It's not that, okay.
And they sit down, we can understand.
Set down, it's when the case is coming, it's set down for bail application, it's set down for trial, it's coming for a particular hearing. That is the set down.
Beautiful, you got it. Thank you.
Okay. I'm happy. I'm also happy you also got it.
Can you thoroughly be admitted to bail?
It's very practical.
Yes. Okay, guys, but we can't learn everything here, ladies and gentlemen.
Can a parole be admitted to bail?
A what?
A parole, a person has been given a parole and commits a crime. Can he be admitted to bail?
Everyone can apply for bail, but the question would be the attitude of the state. Do they oppose or do they not oppose that bail application? And then the court, when it is hearing about, I guess for this parole, it means that there's a further case now. It's something new, not what they are doing parole for. Like after they've been set, parole means that you've been found guilty, you've been sentenced, maybe you've served a number of years in jail. Now your sentence has been shortened in that part of that imprisonment, you are doing it outside. So now while you are out on parole, it doesn't mean your sentence is finished, but you are given in terms of, the rules of correctional services, that they have considered you that you are someone who is eligible to be released on parole. So the sentence that the court has given to you is still there, and you are still a convicted and sentenced person. Now there is a new charge. Now, automatically, by you being someone with a previous conviction, then we can safely assume that the court will be informed by the prosecutor that they are going to oppose your bail application. But then if you want to insist and then apply, maybe you believe that this new case, there's no strong case, there's insufficient evidence, it's not something that can stand, you know, a conviction can be found out of that case. Then you can apply as a parolee for bail application. Yes.
Okay, thank you.
Okay. We move, ladies and gentlemen. Okay, so.
Hello?
Yes.
Yeah, myself. I just wanted to ask something. Where a person is arrested, maybe for murder, for instance, and is linked to another case, maybe at a later stage for hijacking, are these cases going to be combined for bail application, or application will be done separately? So what happens there?
It depends on when they discover the link of these offenses to this person. Sometimes they, like you said, first time it was just murder that they're arrested for, and they do the bail application, and they actually succeed to be granted bail. So they are released on bail. Now, when they are out on bail for murder, the state now comes and puts a further charge of, you said what, you said what? Hijacking, robbery with aggravating circumstances. Now, that bail has been done already. So if he wants bail on this hijacking, he has to come again and apply for another bail, because armed robbery, obviously, it's one of the very serious offenses that is a Schedule 6 offense. So automatically the state will be opposing bail. So he'll have to come a second time. It may even be to a different court, even a different jurisdiction, or then it will then have to, he'll then have to apply for bail. But now, I'm coming. Let me not say what I'm about to say, because I'm going to address it shortly. So yes, it can happen one bail after another, but the second one, the children are also getting tired, ladies and gentlemen. Okay, sorry about that. So, and then the second court would have to be made aware that this person, he was granted bail for murder, and they are seeking another release on bail. Okay, so
understood. Understood. Thank you.
Okay, so the courts should always avoid improper pressure when considering a bail application. Here we are talking about where there is a threat that, for instance, an accused will go on a hunger strike if their bail is refused, or that there are community members from where the accused stays who are opposed to the court granting this accused person bail, as we often see with these high-profile cases, that you will have community members coming to court and toying outside the building. You will see our elders, and particularly the females, coming in their uniforms there in court. Even inside the courtroom, they will be wearing special T-shirts that are saying no bail for rapists, no bail for rape murderers. You know, remember, the presiding officers are human beings like you and me. They watch TV, they are on social media, they are fully aware of what is happening in our society. However, they are still expected to be impartial in how they are going to preside over their cases. So, but then it becomes an issue of how much can they disregard? Because once you know something, you can't forget it, you know? Or once you've heard something, it's not easy to not remember it, you know? So then here we are just saying that, you know, it doesn't, yes, they should avoid being pressurized to not grant bail just because there's a whole noise that is being made. Each case must be treated based on the facts that are presented before the court. So State versus Fernandel and versus the Minister of Justice, here the court held that where such a threat creates a basic and untenable challenge to the legitimacy and the credibility of our legal system and our courts, the judicial officer should not succumb to such. So maybe if, let's say, the court is feeling that they cannot make an unbiased decision, then maybe the best thing for them to do would be to recuse themselves. Here, ladies and gentlemen, I'm not sure if, but there's this famous TV presenter who does a popular TV program of people who are cheating on their partners. There was a time he was involved in a criminal case. Initially, when that bail application was done, the presiding officer who was supposed to deal with that case, he didn't say so, but because of the uproar from the community, there was too much noise where people were opposed to the applicants getting the bail. I remember in that particular case that the initial presiding officer who was assigned that case, before the bail could be finalized, in the middle of the application, the presiding officer asked to be recused from that case. So because maybe he felt overwhelmed and just felt that they would not be able to make a sober judgment of the matter. So the rules of evidence for purpose of bail, we've discussed it already, that they are relaxed in bail applications. I've given you that nice example of hearsay evidence that is allowed. And you can check that case if you want to also learn more about that.
Sorry,
Yes.
I have a question, sir.
Yes.
My question is there a system at court where each offense where bail, for instance, the amount of bail is written for each offense, or does the presiding officer just decide on how much the accused is gonna get bail for?
No, there's no book like that to say if you steal a chocolate of 20 rand, bail must be 300 rand. No, there's no such. Like I said, it's a holistic view of all the evidence that is presented on the side of the defense and the state that the court must take into consideration to arrive at the amount that is suitable. So there is no suggestion to the court like a minimum that they must put or a maximum that they can put. There's no such a thing. They must just apply their minds to each case.
I'll see.
Yes.
Sorry, the other go.
I just want to find out what happens if it is found out later that the investigating officer has lied in his bail opposition. And yeah.
Who lied?
The IO, when he is opposing bail.
The investigating officer has lied.
Yeah, just in case he spoke lies, because everything is based on hearsay, he's presenting nothing. And the accused is denied bail. So later it is found out that the IO was, the investigating officer was untruthful. Is there any recourse?
First of all, the investigating officer will give evidence in two ways to the court. Either through that affidavit statement that is going to be prepared by themselves personally to tell the court about the case that is faced by the accused, and they'll express also their attitude on how they would wish the court to treat the issue of granting bail, or if they are not opposing, they will say even their reasons why they are not opposed to the court granting bail. That's an affidavit. This is under oath. So even if they come to court, they are going to testify under oath. So anybody who lies, either through an affidavit and also in court, they are being giving this evidence under oath and they're lying, then we all know that it's perjury. So they can be charged for doing that. But I wonder why they would do that. But yeah, I've answered you.
Sorry, ma'am. Sorry. I'd like to ask: is the status of the accused taken into consideration with regards to the amount for bail?
When you say status, exactly what status?
Social status, ma'am.
Social like what? They can dance too much or they talk too much or what? What is exactly about their social standing?
With regards to maybe, ma'am, the wealth of that particular accused.
Okay, are you saying if they're poor, the court
Yes,
will then have to be made aware that they don't have money?
Yes, ma'am.
Yes, then there's other forms of securing the release on, for instance, what is called a free bail, that is release on warning. Then that is what you will say.
Okay, thank you, ma'am.
Yeah.
Hello, Mr.
Elsie,
Yes.
one question. The schedules, the schedule 2, 3, 4, and so forth. For example, in part 2 of the schedules, murder is listed, but then also in part 3, murder is listed again. Why is that double? Yeah.
That one, please, ladies and gentlemen. There's this thing called schedules. This is the best way I'm going to try and explain it without creating a debate and also not to prolong the issue. There's a categorizing of offenses from less serious, more serious, and very serious. So the gravity of the offense, severity of what is likely to be the punishment dictates where the charge would fall under. So murder, for instance, there's nothing normal, but I'll call it that. There's the normal murder that we know, but there's also what is called premeditated murder. You see, so when we are talking about these two types of murder, the type of sentence that is going to be imposed, it's not going to be the same. So please, the schedules are part of the Criminal Procedure Act. It's long, it's lengthy. You can read up on them to just help yourself to have an understanding, so that especially when you come to court, the state will be asked which schedule is this offense falling under. And because of that issue that you are mentioning now, then there's going to be a debate that can happen where the state will say it's this schedule, and automatically if it falls under a particular schedule, then it will mean that a bail should be opposed. But you may come and say, no, this offense should be falling under, maybe it's a schedule, there's a non-scheduled offense, the schedule 1, the schedule 4, schedule 5, schedule 6. So whatever the schedule that you will be saying it falls under, maybe you will then use that to say the state should not be opposing. So please, guys, it's a whole other training when we are talking about the schedules. That is something you can do on a self-reading, and also you'll use that whenever you are faced with a case. Then you go and check where your offense will be falling. But the essence is that the schedules mainly affect the issue of bail, whether bail will be opposed or not opposed. And certain actions will make for an offense which would have ordinarily not have been where the state would oppose. But now, because it's a second one, now the state will say, no, it's ×2 now. We are opposing bail. So please, that is for self-reading. I can't just say anything more than that. It's in
Just
the...
to make
Nasibe, if I can ask you a question. if I can ask a question, just to take you a step back, you earlier mentioned that there is no set amounts for bail and it's a prerogative of the court, right? But my question is, does the court consider the means of the accused in determining bail, or do they just come up with whatever figure? So, for example, if the person is unemployed or whatever.
Yes, that is why I said the court will not just look at the state case and say, this is the case that the state has against you. The court must inquire into the personal circumstances of the accused and also the affordability issue, and determine whether the amount that it wants to fix, is this going to be an amount that the accused will be able to afford.
Okay. Thank you. I had missed that. Thank you.
Yeah.
Sorry, on your last on the slide, the last bullet, the rules of evidence for the purpose of bail are relaxed. Please, could I know why is this relaxed?
Because I said during a bail application,
yes,
you don't have access to the docket. You don't have a right to having access of the docket. The court itself, it cannot ask to be given the witness statements to see what the witnesses are saying. So at that stage, the court has to make a decision whether, considering what is alleged, this person can still be granted bail. So it cannot just be the court be informed that the charge is that of assault. Or let me say something a bit more serious, something like the charge is that of robbery, common robbery. And because it's common robbery, the court can just automatically say, I grant or I refuse. The court would want a little bit of information that will not be too much for the court, because the court must still be mindful of the fact that this is not yet a trial. We are just only dealing with the release, whether this person is eligible to be released on bail. Because of that presumption of innocence, it's pressing the court to say, try and release this person because they are maybe possibly not going to be found guilty. And because they are innocent, don't limit their freedom by keeping them in custody unnecessarily. So the court will want a little bit more information so that it can be at least having at least maybe a summary of the type of case that the state has without going into too much detail. And then it can make an overall assessment of whether the state has a good case there that is going to lead to their colleague who's going to be dealing with the trial, possibly maybe finding guilt or not. So if then the court has a little bit more information than to just say the charge is robbery, at least maybe a little bit information of the incident, what led to this accused being said to be the one, and not too much information, and then maybe things like previous pending cases, previous convictions, considering all of that, and also maybe also if the accused wants at that stage, they can give their own statement to the court that is hearing bail to say, I'm going to raise this as a defense in the trial, and these are my reasons. I'm going to say it was a self-defense. I'm going to say maybe there was consensual sex. We were in a love relationship. That is why the evidence proves that there was sexual intercourse. Only though the issue will then have to be debated in the trial, whether there was actual consent or it was forced. You see, so the court will then just on the face value deal with at least some information to help them to make an assessment whether they can grant bail or not. So then the best person to give some picture of more about what is likely to come in the trial, it will then be the hearsay, because in most instances we don't allow the witnesses to come and testify in the bail application, because remember, the proceedings of the bail are actually court recorded. So anything that is in the similar way, anything that the accused is going to say in that bail application can and will be used against them if it is something that is going to be prejudicial to them at the trial. So in the same way, the state would try to keep their witnesses out of that process until the matter actually reaches trial, so that it's not going to be too much trauma on top of trauma, you know, because once they call their witness to come and take a stand and testify in the bail application, once they've testified for the state, now you as the defense, you are going to be entitled to cross-examine them. And it can lead to a mini trial situation where you are actually discrediting them already in the bail application. So they want to also safeguard, you know, also that from happening. So the best way to deal with that is to have the investigating officer maybe then being the one who, because he's interviewed all the witnesses, he knows what is sent for testing and the type of evidence they're likely to bring in the trial. So in brief, it can just come and give an overview of what the state case is going to look like.
LT,
Yes.
can I just interject for a second?
Yes.
On the question of the relaxed evidence, can one then surmise that the reason for that is because it's still pre-trial stage?
Yes.
And evidence haven't as yet been presented.
Yes.
That's why you have the situation where this relaxed
attitude
is.
Yes. So yeah, that is that. So for instance, if there's going to be a medical evidence that is going to be produced by the state, they wouldn't even give those documents to the court. They will just mention that in support of the allegations that we have against the accused, we will also present medical evidence in the form of, you know, J88, which is the forms that are completed by the doctors who examined the victims. If there's going to be DNA, they will mention that, you know, we've sent samples for testing if they've already managed to do that. But they won't disclose them and make the court to know the full details of that. Okay. We move.
Yeah, thank you.
Thank you.
Sorry, Elsie, before you move, maybe you've covered this. I didn't maybe hear you, but I want to ask, because you mentioned that the court refusing bail on the accused, it doesn't suggest anything towards his character or person. And now I want to ask, if the accused decides to abandon bail and decides to not apply for it, does that suggest, I don't know, to the court, some sort of guilty? I'm sure you get the question I'm trying to ask.
Yeah, no,
Yeah.
I do get it. It doesn't imply, maybe the accused is in a situation where at the moment the funds to pay for bail are not there, and you know the type of offense that you are dealing with experience, you would know that even the state will tell you that no, we are going to, if the court, you know, is granting bail after we oppose, we will suggest the court to impose maybe 3,000 rands, and you know, you don't have that money at the moment, without wanting to deal with the matter at that time, then you can say, okay, we are abandoning the bail for now, and when the funds have been secured, then you come and you bring back the issue of bail. You see, so it doesn't reflect on the fact that maybe they're abandoning because they know they're guilty, if that's what you mean. No, it may be for any reason that they may consider. Like, for instance, the situation I've mentioned of our senior citizens who like to come in uniform to oppose those bail applications. Like I told you, the presiding officers are human. And when the allegations are mentioned there in court, those mothers, they have a tendency of breaking out in this cry you know, like, I'm not saying we are inhuman, we don't sympathize and anything, but you know, those things, they get to the presiding officer because he's human. When the courtroom is, it's filled with, you know, sobbing and, you know, when, you know, because obviously the state will stand up and mention the severity of the charges that are faced by, you know, and reading out, you know, what the accused is likely to be dealing with. So things like that, you know, when you see that, yeah, you may have to make a judgment call and decide, let, you know, tempers to cool. Don't bring that application when things are so heated, you know, because sometimes, you know, yes, there's an order that is kept inside the courtroom by the court orderlies, the police, members of the police that are there to ensure that people are behaving inside the courtroom. But someone can just stand and, you know, burst out insults and whatever that they want to say. And the court is there, is hearing, you know, all that drama that can happen. And we have seen, even in TV, where people were removed inside the courtroom, you know, because they were disruptive, they were, you know, blaring out, you know, statements which will paint the accused to be like a monster. And, you know, so when you are, you know, sitting with that situation, you may actually consider actually abandoning the bail and bring that bail application. Remember what I would do when the situation is like that. You are entitled to allow the state to postpone the matter to a future date where they are obviously going to say they're still doing their investigations. And at any stage, while they are doing the investigations, you approach the prosecutors and say, now we want to bring this matter for bail. Maybe you've assessed that, you know, tempers have died down a bit. Then you will go to the prosecutor and say, please, I want to do a requisition that the accused must be brought before the actual date of hearing, where the whole world knows that this matter is coming again on the particular future date. Then you make arrangements with the state that the accused be brought by correctional services before that date, hoping that there is no one who would then be you know, blowing the whistle to members of the media again and say, you know what, that case is actually coming. Because only if someone alerts the media, then they would know that the case is coming earlier than the date that is known to everyone. Then you can possibly have your quiet time. Not to say the evidence will not be presented in a similar way, but at least that drama, that improper pressure that we are talking about, it will not be present. At least it will be professionals dealing with the case. And when I say professionals, it's the professional lawyer, it's the professional state prosecutor, and a professional presiding officer, you know, considering the application that is before them, without any anjunyana kind of, you know, because, you know, those things, they affect the presiding officers, whether you like it or not.
Hi, Elsie. I just want to
Yes.
ask, in a case where evidence is led in another platform, for example, in a state commission inquiry, will that be considered when it comes to bail application?
No. No. The state has to make its own case for them that they will proceed to prosecute. So if they want to use a hearing like that, which I don't know, you mean like those ones like the state capture, whatever kind of, I saw that because those were televised and the witnesses were testifying under oath. So yeah, if for instance, in a case like that, the state wants to now proceed with a prosecution of, I don't know who would be the accused in that case. So remember,
Okay.
those testimonies were made before a sitting judge under oath. So if you would want to make reference to what was said there, without, you know, dwelling too much into the proceedings of that outside platform, I believe you can be able to do so because those were made under oath. if you want to bring issue of maybe to show consistency in the testimony of the witness or inconsistencies, that maybe while you testified in that hearing, you said this, but now in this, and that was under oath, and now in this court, you are now coming with something completely different. So yeah, I guess you can say that, you can use that.
Okay, thanks.
Yeah.
Masebe?
Yes.
Hi, Elsie. On the issue of the waiting and then applying for bail at a later stage, like I'm of a different opinion that the liberty of the accused cannot be outweighed by someone who cannot respect the courtroom. So if I was the defense, I would actually bring the application. If the court decides to not to grant bail on the basis that there will be public unrest and everything, then it's fine. Then later I will then bring a application that the circumstances have changed, because I know of a case whereby the facts were similar, whereby people were angry and everything, and the defense attorney said, no, this person has an uncle somewhere outside town and he's willing to accommodate him, and bail was granted.
You are entitled to your opinion. That is your way of doing it. But I'm just saying you are risking that at that moment, under that and improper pressure, because it is pressure, whether you want to accept it or not, that is being, put on the presiding officer somehow, not directly, maybe to go and say, refuse bail on his door, but they are human, they are seeing it and they are hearing, and, so you will decide. Like I said, you will decide. If that's your approach, it's your approach. But you are risking the likelihood that the bail will be refused. And now when you have to bring a bail again, it's now going to be an issue of you either bringing a bail on new facts that the court has not heard at all before that same court, or now you're going to have to go to appeal in the High Court, you see. So that is why I was saying, just decide, but it's fine. We've answered that one. So ladies and gentlemen, we are moving. So there's different forms of bails that you can get. The first one that you are mostly going to expect to get, it's what is called a police bail. This is in terms of Section 59 of the Criminal Procedure Act, which authorizes police officials of a rank of sergeant or a higher rank to fix bail before the first appearance of the accused in court. That is for offenses that form part of what I spoke about, the schedules. So you'll check there which offenses fall under Part 2 and Part 3. But generally, these are they are less serious in nature, like your common assaults, your malicious injury to property, maybe driving without a license, where one of our colleagues even said the police can just give you a document to say a notice to appear. So that is something that you entertain with a police official. Next one is at the police station still. Section 49A authorizes the members of the prosecution to make a release on bail before the court first appearance, if the accused is in custody for a Schedule 7 offense. Now, such offenses are slightly more serious than those where the police on their own may actually fix a bail or release an accused on bail. Here we are talking about your assault with a grievous bodily harm, culpable homicide, common robbery, theft, and fraud, where an amount involved does not exceed 20,000 rands, and in some cases of possession of drugs And if the amount of drugs involved also is not an issue that is too difficult for the prosecutor to can apply their mind, they can also grant bail. So at the police stations, on a daily basis, there is a stationed prosecutor who is on standby. When you reach the police station, if the police officer says, no, this one, it's not something that I can give you bail on, you can ask to then speak to the the prosecutor who is on duty to entertain what is called after hours bail. Now, if at that after hours bail situation, you still don't get bail, you are now going to proceed to court.
Ma'am,
Okay.
can you please go to slide 27? There's something I want to check quickly.
Really tell us why. We're trying
No,
to
there's something I missed. Sorry to interfere.
Mary,
I
you
just want to
have.
assist.
Where's your slides? Everybody got the slides. Hmm?
Thank
Police
you,
bail.
ma'am. No,
So we
thank
must-
you, ma'am. You can proceed. I confirmed it.
Okay.
Thanks.
So please visit the schedules, and then it will also help to give you clarity on where can you fight the stationed prosecutor to give you bail, and where anytime they are not comfortable, where they feel that I don't want to, go beyond what would put me in a position where I'd have to answer too much on why did I grant bail here and whatever. The general the general treatment that you will get from them is that they will tell you straight, you know what, please go and apply for bail in court because I don't want to burn my fingers. So the general powers or the duties of the court now during a bail hearing is to obviously hear the bail, but the court can postpone the proceedings where necessary. Check the provisions of section 60 as a whole, guys. It's a very long section in the Criminal Procedure Act dealing with everything concerning bail, but here I just try to give you the specific subsections that you can check about postponements. I've talked about the 7 days issue where the state would try to drag out that postponement to be up to 7 days. So read up on that. To request also, the court can also request information that it needs for a decision in an informal manner, if the state and accused do not dispute this. Section 60, subsection 20B. To require that the prosecutor or the accused lead evidence of matters that are in dispute. Here, we are not trying to turn a bail application into a trial. Maybe the court just wants to get a clearer picture of a particular issue, not the entire case. Then the court can call. For instance, when the investigating officer has submitted that affidavit, they do tend sometimes to be too brief, that the court may feel that I want the investigating officer to come and address me on this issue and that issue. So that is where now you would most likely have to be having evidence, oral evidence being led. Now, the court can also require that the prosecutor place their reasons on record why they do not oppose bail on a charge that is falling under Schedules 5 or it's a Schedule 6 offense. So those are normally what would be expected that they would oppose, and they will have even certificates that they will produce to the court to say that they are entitled to oppose bails. And if these are serious offenses, so if they don't oppose, then it becomes questionable. Why are you not opposing? We are talking here about your rape, robbery, armed robberies, and car hijackings. You know, so why are you not opposing bail? Because the schedules are there to list out those offenses, and if you say that you don't oppose, then it must be placed on record why.
Elsie, can I
And
interrupt you? Sorry.
yes, yes.
If you look at bullet B, there's no section 6020B. I think that's a misprint because if I'm looking here under section
it's a 2B, sorry, because you can see this is
No.
section. Yeah, it's
Okay.
2B. Because can you see?
2B. Okay.
Yes, also there, you see before it says section 60, there's a 9 there. So sorry, guys, it's my typo.
Okay.
Please. Yeah, thank you for alerting me of that. I'll change it for the future. So it's not a 9 section 6020B. Sorry, it's a typo. Human error. You see, ladies and gentlemen, thank you so much. You see, this is where we pick up those tiny mistakes that actually turn the whole shape of the case that was going south. So thank you for that. Yeah. Okay. So in order that further evidence or information be placed before the court, then if such is necessary, then the court will call for further evidence, and the court should also first consider whether or not to grant bail, and then that is how it works. The court will then say, is it comfortable to grant bail? And if so, then inquire into the suitable amount of money that the accused would be asked to pay for the bail, considering the accused personal circumstances. Here we are talking about affordability. So while the court is doing this, the court has to determine whether the interest of justice favor the release of the accused on bail, and the court will then have regard to the interest of justice as against the rights of the accused, the prejudice that the accused is going to suffer if not released. So what here basically we're doing what? A balancing act. If I'm granting bail, will the court be seen to be will the court be undermined? Will the court be seen to be too lax when dealing with potential criminals? Will the court be sending out a message that is deterring, would-be criminals, that if you are arrested for this kind of offense, you are likely not to be released on bail? But in the same breath, the court would have to also check. Now, if I refuse bail, this accused will be prejudiced. What kind of suffering will they have? Will they lose an income? And if the case does eventually go on trial and the person is found not to be guilty and actually acquitted of the charges against them, the disruption to this person's life, the perception of the community, as we've spoken about, that, once the paint has already touched you, that you've been known as someone who's been arrested, it's not easy to remove that paint that you've once been arrested, So perceptions are very difficult to change. So the court would then consider all of that and then decide. Any questions before I go into more of some factors that are going to help us to now try and persuade the court to grant bail? Nothing, thank you. So section 60, I think section 60 subsection, I think it's A to E normally, has these factors that the court would ordinarily consider when determining whether to grant bail or not. One, the court would consider, as I've already mentioned, whether the interest of justice would permit the release of this person on bail or not. Now, under this particular issue, when the court has to decide, do the interest of justice warrant this release, the court, you can now say things to them like, you know, the court would have to consider that the period that the accused will spend in custody from the time they're arrested until the trial is finalized, depending also on if you can get information from the state that these are the number of witnesses they're going to call and the type of evidence that they are going to present. I can tell you, if the state is going to use, for instance, DNA, there is a general knowledge that there's a, even I think was it yesterday or the day before, somebody mentioned that at the ballistic, not the ballistics, the laboratories, the South African laboratories that are conducting these analysis of the samples, there's a huge backlog. It was there before COVID, but it only became worse, if there's such a word in English, after COVID, because at the point, things just stopped. As we know, the whole world stopped. And before then, they were still running with a backlog. So ordinarily, when a matter is being postponed for them to do a DNA testing, the state would normally ask for 5 weeks for that. 5 weeks is close to what? For them to send those samples and get results. Almost 2 months. And this person is in jail. Now, I can assure you, we said there's a huge backlog. Most of those DNA results, they don't come, you know, immediately after that 5 weeks. Some even take years, guys. I personally don't know a way of making the DNA to come faster. Maybe someone can help us here. What we can do to make that DNA results to come faster. Because personally, I've even started trials where those results were not, and you know that is the worst thing, to start a rape trial without those results. It's a very huge risk to take. But the state, remember when we spoke about how you lead your evidence in the defense case, that you can elect not to call the accused first. You can maybe start with your defense witnesses and later finish off with the accused. Even the state has the same prerogative. They can decide that we are going to start with maybe, you know, the witnesses as they are the complainants, the first reports, and the doctors who examined. And later on, before they wrap up their case, they will get those DNA results. So as long as it's brought in while the state case is still open, the door is still open for them to do that. So now you are going into a trial reliant only on the word of the accused that maybe they say there's not going to be a match that's going to be made with those DNA. Nothing is going to be found. And the state is, you can obviously try and say, you know, the right to access the docket before, you know, the trial, to be able to thoroughly prepare. You can try all of that. And the state will say, we've given you everything that we have. The only thing, Your Worship, that is delaying to come is this result. So until when will the case be postponed? So I don't know. Can you help us, guys? How do we get those to do? Yes.
Elsie, I just want to ask a question with regards to DNA. Seeing that it takes time for the police to actually provide it, how come the statement of justice delayed is justice denied? So how come, who can hold them liable? I mean, really, to wait for like a year, I mean, really, I don't even have words. for people who are, for victim, whoever, if they're victim of rape. I don't know who can help the police, in fact, because I believe the prosecutor are waiting for the DNA or for whatever from the police, but who can then make sure that they take accountability for that as SAPS? Thank you.
I'm also looking for an answer because
Ma'am, can I come in?
Please do.
Yes, ma'am. In the NPA policy manuals, each and every division has its own directives, but what they dictate or what they give guidance on, not only on DNA. When you talk of your postmortem reports, which they also sometimes delay,
not that
your
long.
ballistic results, your DNA results.
Yeah,
yes.
but I mean the others
When
they don't.
you are given,
Mm.
yeah, when you are given, you are actually given 4 months as a prosecutor to have everything in your docket. So when you don't have your DNA results and the 4 months has passed, you are actually authorized to inform the office of your SPP. There is a letter called expedition letter. Once they do that letter, within 2 weeks, you'll be having your results. So I think
is it a matter of training of the prosecutors maybe then that they don't know?
Unfortunately, I'm one of the prosecutors. We are supposed to know. We are supposed to know.
You will shout because remember we are coming from the outside and we don't really know all the internal operations of the National Prosecuting Authority. So we are at the hands of the court, at the mercy of the court actually, that they will help us to fast track these results to be brought. So if there is actually something like that, and all of us stand before court as officers of the court, we would expect that someone who knows of that procedure would actually, raise their hand and or even if they don't say it in court, actually go and apply behind the scenes and get the results to come.
Once it's after 4 months, you are actually expected to request for that letter submitted to the labs. You get your results within 2 weeks.
But thank you so much, colleague, please, for telling us this, because honestly, it was always the matter to be fighting it out with the court and now having the court to try and press. Yes?
May I also make a comment on that? Part of the problem is at the hospitals too, because when a rape case comes to hospitals, because I'm a labor relations officer and I represent doctors in the disciplinary hearings and at bargaining councils. Now, with these rape cases, what normally happens is that there's a rape kit that's given to these rape victims. And then after that, they need to be sent to labs. Now, the challenge that we're having in South Africa is that there are only 2 labs. The one lab exists in Cape Town, the other lab exists in Pretoria. So there's a backlog of it. That's why there's always a problem that the only...
We lost you. We've lost, is it Mr. Koza? Yes, so we've heard that apparently the labs are centralized, so that also leads to the volumes that they have to deal with. It's quite a lot. That's what we would be told. Yeah, but we will try the 4 months. We will try the 4 months thing.
Elsie?
Yes, ma'am.
I wanted to ask Mr. Koza there, if you get, if you write the letter to the lab and they release the results within two weeks, wouldn't that be lead to tampering of the evidence, because that evidence is supposed to come from the state, the lab results?
No, but it's the state that sent those samples there for testing.
No, I'm saying in the event of backlog, and then he, as the defense lawyer, right? Or is it the investigating officer who
he's
writes?
not saying the defense rights. He says them as the prosecutors. They are expected that if a matter has reached 4 months, they must write the letter to request for expedition of the testing.
Oh, okay.
So
that's
maybe
very correct, ma'am. That's very correct.
Okay,
yes. Yes, so it's them, the state, who do that. You can maybe just make the one who is in court to remember that after 4 months, my learned colleague, you remember that you are supposed to write that letter or to expedite. Yeah, but let's see how far we get with that. But yeah, let's hope that will help us really, because I don't think it's because of any intention or what. I don't really have a clue. Let me not even talk on that, on what's happening at those laboratories. Let me not defend it, let me not attack it. I really have no clue. I will accept that hopefully what our colleague has enlightened us about will help us to go some way.
Can I just ask on that? My understanding there's a backlog of hundreds of thousands of cases, of DNA tests sitting at NHLS. That's why people cannot get the results. So I'm trying to understand that if you then write a letter, then within 2 weeks, you will be able to get those results. So why isn't that been done with the many cases? Because there's a lot of backlogs.
And I'm also imagining that I'm sure that there's hundreds of thousands of those kind of letters that are actually being sent there at the same time. So the question would be, whose letter gets preference?
Hello.
Yes.
Tell me, is there a possibility or is it allowed that due to the fault of the state, right, the DNA tests are actually putting the accused to a disadvantage? So is it possible if the accused wants to get a private laboratory to do the DNA, is that allowed?
No, that's only if you are challenging their results. Then you may seek your own private expert who can come and do their own testing, and then maybe you use that to counter the state lab results.
Okay.
But you can't say, let's say you are a billionaire and you say, look, I'm willing to donate. That, my results go to a private institution, then things like that, they don't work. Line, everything goes by the line. We are all ordinary before the law. So,
right.
Yeah. Okay. So, ladies and gentlemen, that's one. Sorry?
Hi,
That
Elsie.
is to keep the chain intact.
Okay, I think this person is not talking to us. Okay.
Hi, Elsie.
Is it Mr. Koza again?
Hello.
Yes.
Yes. I'm not quite sure if you've covered this. My signal has been really bad. I just want to know, with regards to character witnesses, are they allowed in bail proceedings? Because I know, and correct me if I'm wrong, I think they are allowed in
Yes, we are
is
talking
it
about
sentencing?
Yes, but they will be controlled, obviously. So remember the relaxed part that we read there about hearsay. So something about character can also be introduced, but me, I would strongly, oppose that, because now you can oppose it and say, look, you are trying now to paint a bad picture of the accused, and at this stage we are not in even a trial, so we are just trying to those are the issues that we spoke about, the alias names, those names of gunmen and all those things go into character. So there's the way that those things they get to be, they trickle in somehow, even if it's not like clearly coming at you that you can see. Now a witness will open their mouth and say, the state prosecutor will say, your worship, now I want to lead character evidence now. No, they will not give that clear warning that now I'm going to give. So it will just be thrown in as part of giving whatever information that they're giving, and just in there, you hear that this is character now, and you'll have to do damage control to try and neutralize it.
So let's say in an instance where maybe my accused is working in another province and there's a contention on whether he's a flight risk and they're refusing bail, and maybe me as a defense lawyer, I just bring in maybe his boss and his colleagues as character witnesses. Is that allowed?
Yeah, that's just to give assurance. Remember, what is the purpose of bail? To secure the attendance of the accused in court. So those would be helping to show the court that this person can be relied upon, that they will surely come back to attend their matter. So that is why we verify addresses to show that if the court is looking, I mean, if the police are looking for this person, they have a fixed address where they can be located, you know?
Thank you.
Yeah, that can be allowed.
Thank you.
Okay, thank you. So the next bullet point there, we are talking about the probable period of detention until the matter is disposed of. That is a big issue, especially with your more serious offenses. Guys, there's people who are sitting in custody awaiting trial for more than 4 years, 5 years, awaiting trial for very serious offenses that they've been charged with. For one reason or another, that's the reasons why they couldn't be given bail. But you know, cases, they do tend to drag, you know. We know COVID also was a huge, you know, factor that cost for almost 2 years the court rolls were not moving. Though now, you know, things have picked up a bit to try and dispose. Then a new pandemic has now brought up its head, load shedding. Though also, you know, I'm aware that some courts are doing their best to manage that load shedding, but there are courts that still don't have those generators. Matters are still getting postponed because of things that are beyond the control of everyone there, you know, because of load shedding. So these things, they may happen. You may actually be happy that the stages have changed, that it's actually going off for 2 hours. But if the electricity is off for 2 hours and this happens 2 times during the day, that's already 4 hours. And when you check what are the court hours, courts sit from 9 to 4. So if that disruption happens within that 9 to 4, already we minus 4 hours out of the court time. So that is eating up on valuable time that could have been used to run cases. And in many instances, a lot of cases are just coming, witnesses are coming to court, and everyone is present. And then you are sitting, waiting, 2 hours later. It's already it's already 2 o'clock. And then you can only maybe hear evidence of 1 witness and the state has 5 witnesses. So that witness may even just give evidence in chief. The case is postponed for cross-examination. Now, as many of you have been watching the honorable lawyers that have been, I call them, I don't want to call the name of our colleague who was very, very active. I'm lacking words to describe Mr. Defo, but you know, if you watch that matter, you saw how long they could sit on 1 witness, whether it's evidence in chief or whether it's cross-examination. So they can be leading 1 witness for an entire day. And with all these disruptions happening, so we know that now cases are taking longer and longer and longer to get finalized. So that's a factor that the court really needs to take into consideration if you are going to deal with an issue of either possibly releasing this person on bail. The reasons for the delay will be mentioned. Whether the fault is that of the accused or that of the state, you will say so. Financial loss is a big issue that you can also mention, that the accused is likely to suffer financial loss by them ending up, obviously, once a person has been kept in detention. I don't know of, you know, many employers who would be willing to wait for the return of that person, hoping that they will be found not guilty and come back. So in most instances, most accused, they automatically lose their jobs upon being kept in detention. Any impediment of the defense to the defense that you are likely to foresee that it will be, causing a problem, or any other factor. Many more factors discussed in the case of State versus Anchensen. So please just focusing on, because when the court is, look, everybody, we have words that we use. I said the defense will say justice denied is justice delayed. The state will say, for instance, when they're asking for the 7 days, that they are entitled by, the provisions of the act, that they are entitled to have that 7 days rule applied in a case of bail. So if it's the court that now, the presiding officer that now has to make a determination, they will now throw that interest of justice. They can stretch it so far so that you will be shocked that, so the interest of justice, they can even include this, but they can do that because it's all up to you how far you are willing to stretch it. So even you, to curtail that term, the interest of justice warrants that I refuse bail, then you need to bring in as much as you can before the court, so that it will find it hard to actually pounce on you with that interest of justice, and actually be pressed to now say, okay, the interest of justice actually warrants that I grant bail. So we are all pressing from all fronts. From the defense, we are pressing, the state is pressing, everybody is pressing. Okay. Okay.
Elsie, can I ask something?
Yes.
If you are sitting awaiting trial for 4 years, example 4 years, and eventually your matter goes to trial, and you found guilty, do they minus the 4 years that you were sitting awaiting trial? Let's say you're guilty and you sentenced for 10 years. Do they minus the 4 years and you just do 6 years, or do you do your full 10 years?
You, in your mitigation of sentence, you will mention that. You will mention that this person has already been sitting and spent this time awaiting the finalization of their case. The court should consider that, it's somehow a form of a punishment. So the court should heavily, take serious consideration of that time, because the freedom of this person was impaired. And you can even go, yeah, I'll come to sentence, I'm leaving it. But yeah, you can. Okay.
Can I interject, ma'am?
Yes.
In the same question. What if the opposite happens? Then the person is not found guilty and they were sitting there for 4 years.
The person is found not guilty. We celebrate. We jubilate.
What about that 4 years that he served or she served in custody, and how is it gonna be refunded? If that's the right way.
Yeah, I hear you, but then you would have to decide, are you feeling that they were wrongly there, like it was an unlawful, then you have to go back to what we spoke about. Was it an unlawful detention for them to have been there? Was the state, in a position to have earlier decided to not proceed with this case, and they were negligent in not reaching that decision faster? Sorry.
So basically you sue the state now.
Yeah, you can sue the state, madam. You like suing, yeah?
I'm just asking.
See, I've got a question here, man.
Yes.
Tell me, so the 4 years he stayed while not out in bail, should he be found guilty, will that be considered in the sentence?
Sorry, I moved away to just open the door. Can you repeat the question again?
I mean, the person who have been denied bail inside for 4 years,
yeah,
should that person be found guilty, will that 4 years be considered during sentencing?
Yes, that's what I said. You will ask the court to take into consideration that time, but the court does not have to say that but it's a mitigating factor that you will also put forward and say, Gibson, Gibson, I don't know what you mean. Maybe you can tell us. I like laughing because you guys are too serious for me. But yeah, you will also put that as a factor that the court should consider, and hopefully they will see your reasoning and agree with you. In most instances, they actually do. They will sort of like discount in a way what they would have ordinarily given. So instead of 10 years, then you will get 6 years.
Okay.
Yeah.
I have a question.
Yes.
So is this to say that there is no written rule to say that they have to automatically discount the sentence? Say, for instance, the person has been in jail for 4 years, and was awaiting trial for 4 years. After the trial, they are found guilty, and they are sentenced to 15 years. So there is no way that it's written that they have to minus that 4 years from the 15 years, and they only get 11. Is it more a matter of discretion on the side of the court, or is it your duty as the legal counsel to actually make the court aware that they need to take those 4 years into consideration?
You would use case law precedents, because remember the hierarchy of the courts. Certain cases that are decided by certain courts create what we call precedent. It means if you are a lower court that is presiding on case that is of a similar nature with the same type of facts, then if a higher court dealing with something similar to that has sentenced in a lesser format and or actually took that say the time to take and spent in custody, if that was considered to be one of the persuading factors that the court must consider when considering the sentence, it's a precedent. It cannot be ignored. And if this lower court is ignoring it, so now, and the court is now going to give that harsh sentence, you will now take this matter up for appeal and say, you know, that court was too harsh, and then you will use the case law that you have to show that even higher courts have said the courts must consider these factors. So yeah, that's how you would approach it. But we're coming to sentence. Please, let's not too much dwell on sentence. Let's finish this bail assembly. Please, we're running out of time, ladies and gentlemen.
What if that person dies while in detention?
They die, and then automatically the charges are withdrawn. The state will they will present the court with a death certificate to confirm that the person has died, and they are withdrawing charges.
Okay.
Yeah. Okay. Now, the next one is still on this section 60. It talks about the court will take into account public or individual safety before it grants bail. When you want to persuade the court there, you will mention the issues surrounding the degree of violence that is implied to have been used in the commission of the offense. So, for instance, where you will say the state maybe is saying it's attempted murder, but the indications of what you've been told by your client is that there were not even any real injuries that were sustained. You know, it was just maybe a matter of just pushing and shoving each other, but there were no injuries that were sustained. If there was yeah, I don't want to dwell, guys. Degree of violence also we will mention. Maybe it was not a real gun, but that doesn't take you too far though. Maybe you will say it was a toy knife. It was not actually a real knife, you know, that was used to scare the victims. But still be careful there. You might be implicating your client too. You'll have to see how you phrase it in a way that doesn't suggest that your client is guilty. I see that people are saying 7:30. Ladies and gentlemen, 10 minutes. We come back 7:40. I also need a bathroom as well. 7:40, thank you.
Hello guys, who is in Marisbeck? Any group formed in Marisbeck? Marisbeck.
Guys, even during break, please mute your mics. The crunchy sound. Yo, wow.
Group in Marisbeck, please. WhatsApp group or anything.
Guys, I'm struggling to add everybody on WhatsApp. I don't know if it's the network or what's going on. I gave my number. Please drop me a WhatsApp so that I can try my best and add all of you.
Okay, what's your number?
I have also added my number on the chat box. So if anyone has the WhatsApp group, can you please take it there, or can you please give me yours so I can text you and then you add me on the WhatsApp group.
Okay, I'm gonna share my number quickly on the chat.
Okay.
Now. Just send me a WhatsApp and I'll do my best to add you guys. I don't know WhatsApp problematic. I've managed to add a couple of people tonight, but it's really a struggle.
Okay, what's your number?
I'm gonna add it on the chat now.
Hi, can somebody please add me to the chat so that I can send messages as well? Because I'm trying to send messages and it says you can't send messages because you are not a member of the chat. So I don't know what to do. Anyone?
Hey, me too, say I have the same problem. I can't send messages here on the chats. I don't know what's happening.
Please add my name on the chat book, on the chat group, please.
Rushaka, andisele paper towel. Andisele paper towel. Paper towel.
Can we please mute and not talk our things? Even me, I'm busy talking here, but you can't hear. Please,
Sorry,
let's
guys.
not
Sorry,
be
I
on the
didn't
mics.
realize I muted. Sorry.
Vulikiza lapho ayini oba ayinayo.
Please mute.
Now.
Okay, ladies and gentlemen, please let us proceed. So we are still under this the factors that the court would consider for public and individual safety. We will check the degree of violence that is implied to be inflicted on the victim, as I said, and any threat of violence that the accused makes on any person, and any resentment the accused is alleged to harbor towards any person, and accused deposition towards violence as evidenced by their past conduct. So here the issue of character will find its way into the bail application. Now, the disposition of the accused to commit what is known as Schedule 1 offenses as evidenced by their past conduct. The prevalence of a particular type of offense within that court's area of jurisdiction is also something that the court will look at closely. And any evidence that the accused has a previous conviction or the accused has previously committed as a Schedule 1 offense while out on bail. This makes matters even worse. So you'll have to rebut these factors when you now want to assure the court that the members of the public are not going to be in danger of the accused, because he's not a dangerous person. He's not someone who is prone to committing violent acts. He's someone who hasn't got or who's not someone who has grudges with the state witnesses, and this is probably his first brush with the law. So those would things that would be used to persuade the court that the public and the state witnesses are not going to be in danger at the hands of this accused if they are granted bail. Factors considered by the court on whether one will evade trial. The court will check that the accused has what is known as emotional ties within the area of jurisdiction, and if all the family members of the accused are living within that area, or if they are, say, in a case of a foreign national, the accused has all the family members are living outside the country. So if there is no emotional, no family ties, then it becomes, more challenging to persuade the court that this person is not going to evade trial. Any assets that the accused has in the country, outside the country, any means to travel, where we are talking about traveling documents like your passports, or the ease of the accused to move within countries. How easy will it be for this person to go out of the country unnoticed? And the extent to which the accused can afford to forfeit the bail money. Remember, the bail money, once it is paid, it's only going to be refundable once the case is finalized. So if we say fixed bail, we have to check, can this person risk to forfeit that money? Because if they don't come to court, the funds that have been deposited to pay for bail eventually are going to be forfeited to the state. So you can think of the popular pastor that was in Pretoria, who, after he was granted bail, And it was a hefty amount that was paid for that bail. But it was easy for that accused to leave the country, and his money has now been forfeited. So we will have to check the nature and the gravity of the charge, the strength of the state case. Do they have a strong case? The nature and the gravity of the punishment that is going to be imposed should this person be convicted. The binding effect and enforceability of bail conditions that we spoke about, whether this person will be able to abide by the conditions or it will be easily breached. The likelihood of a heavy sentence being imposed in the event of a conviction is also a factor. Check the state versus Hudson to see how the court dealt with that one. Now, the strength of the state case was dealt in the matter of Stes versus Lubak. And there, this is where now the charges are very serious, and now you will have to now poke holes into the state case that you don't have all the information on. But whatever little information that you may be able to elicit from your client, you will now have to use that to try and see and show the court that the state case is actually not even that strong. I move. The next one is factors to be considered by the court whether intimidation or influence of witnesses is possible. Now, whether the accused is familiar with the identity of the witnesses. Does the accused know the witnesses and the evidence that they can give against him? Does he have access to them? If he doesn't know them, then why would we think that the accused is likely to intimidate or influence these witnesses? What kind of a social standing that one of you has mentioned here do they have? Are they known to be one of those very well-connected people who have long reach, you know, within their community, that they have ways of getting to people and getting things done to people from a distance? So it may be direct or indirect, that kind of intimidation. And whether the witness have already made statements or have agreed to testify against the accused. Whether the investigation case is still ongoing or it has been completed. The relationship of the accused to the witnesses and the extent of possible influence of these witnesses to either cooperate or not to cooperate with the police, or maybe possible intimidation that they must not testify against the accused. So how effective would it be possible for the accused bail condition prohibiting communication between them be possible? Whether the accused has access to the evidentiary material which is to be presented at the trial, something that is kept at SAP 13. Can the accused access it? Does he even know what kind of evidence the state is intending to present at the trial against him? The case with which the evidential material could be destroyed. Now there is, can he easily access that evidence? Can he somehow get it destroyed? Those are the factors that the court will consider. It's a lot, but it's just to help you to not just read it as one line. You know, and what I'm mentioning here is not all of it. It's some of it, not even a huge part of what the court will consider, but I'm highlighting things that are most common that the court will be concerned about. Now, when the court has to determine whether the criminal justice system is going to be undermined or not, the court will check whether the accused deliberately supplied false information at the time of his arrest or during bail proceedings, whether the accused is in custody on another charge or is on parole, as the earlier question where we were asked, can someone who's on parole apply for bail? So there's your answer. Yes, they can. But how will the court now view this person who's already appearing before the court as a previous, as a convicted person, someone with previous convictions? Any previous failure to comply with bail conditions. You see, when I was discussing that, don't just agree because you are desperate to have your client released on bail. And when the court sets conditions, you just say as it pleases the court, and tomorrow the client is found to have violated or rather not complied with the bail conditions. It reflects badly on the accused, or any indication that the accused will not comply. So that's what you should consider. Factors that the court considers in determining the likelihood of release causing a public disturbance or undermining the public peace. Whether the nature or the circumstances of the offenses are likely to induce a sense of shock to the community in which it was committed. Now, this takes us back to my example that I spoke about, a court being somehow influenced when there's a community uproar, where the community is strongly opposed to the granting of bail. And whether that shock or outrage might lead to a public disorder if the accused were to be released. Whether the safety of the accused might be jeopardized by this release on bail. So this means if the court grants bail, immediately the accused walks outside the court, the accused might be even attacked and killed. Is that now whose responsibility now will it be? Because now it will be a matter of, the court not having ensured that safety of the accused. Whether is the release going to undermine or jeopardize the public's confidence in the criminal justice system? The issue of possible disturbance was dealt with in this case of State versus Mohammed and State versus Bennett. So please see there, and there's many others, ladies and gentlemen, even in your manuals, look there how these issues are covered by the courts, and make up your own mind when you have all these high profile cases, because they are very, very common nowadays. How you would handle it, it's entirely up to you. Now, in a Schedule 6 offense, the accused is expected to adduce evidence to satisfy the court that exceptional circumstances exist in which the interest of justice permit the release of the accused on bail. In a Schedule 5 offense, the accused has to satisfy the court that the interest of justice warrant the release. So the difference between these two is that with a Schedule 6, you have to show more of a special circumstances that an accused have. And there is no specific definition of what is exceptional circumstances. Each case is to be decided based on its own facts, but you can use case law to persuade the court that the factor that you are bringing up was also cited as one that would qualify as an exceptional circumstance in one of the standing precedents that have been made by our courts. So there is no definite like a list of what is exceptional circumstances, because every case is unique. You will have to now dig deeper and find those things that make your client to stand out and have those factors that the court must consider to press the court to grant bail. Okay, just to mention a few exceptional circumstances that are commonly mentioned in the cases that we have, the case law rather. Sickness is not on automatic, like disease. If you are the accused suffers from a particular disease. Like I know of a case where the accused lawyers were saying the accused suffers from a disease that, as the prisons, they do have hospital sections and doctors that attend to the inmates. But I think it was a rare form of cancer that the accused was having in that case. And they were saying that the accused should not be kept in custody because the prison does not have the facilities that would be able to cater for the medical needs of the accused. So we are not just talking about just someone who is just taking pills and going to sleep, maybe dialysis. And I mean, I don't know too much about cancer, but I know that the processes that the treatment that they undergo requires special machineries, and actually they need to have a dedicated staff that attends to the cancer patients in the institutions that deal with them. So the correctional services don't have those facilities. So you would see how, if, for instance, you have such a serious sickness, and how you would use that to persuade the court to grant bail. Okay, so what else? My brain is freezing. I'm trying to think of exceptional. At the point, HIV was one of the highly mentioned. If someone was HIV positive, it was one of the commonly used reasons that was mentioned to the court, that the accused was suffering from HIV and that they would be compromised, their health will be compromised if they are in custody. But then the facilities were improved in that the inmates are being provided with the medicines, you know. So maybe, I don't know, but yeah, you'd have to think up what you would, on medical grounds, to say the court should not make this person, because there are instances like if you've seen with our former president, Mr. Zuma was not kept in the normal detention cells with all the other prisoners, not only because he was a president, but I think they argued health reasons. So he was kept in the hospital section of the prison. And it was said for some medical reasons. So,
ma'am, for medical reasons, can they consider house arrest?
House arrest is only a factor that comes in after sentencing. So here we are still asking the court to grant bail, right? So it's either this court is going to grant this person bail, and you are going to say the court should not put this person in custody so that they can be able to receive proper medical care, which cannot be provided while they are in custody. So, like, for instance, someone also brought up an issue of someone who was wheelchair bound with a need for, I don't know, it was a breathing issue or whatever, and the state needing to give that particular inmate special attention, you know, and the way that the prison is built inside. Unfortunately, maybe I should actually make a trip with my colleague who goes inside the prison on a daily, to just go with him and actually go inside. It just won't be nice, ladies and gentlemen. But sometimes it's good to go into the field, you know, and have first sight of how it looks in there, you know, because they were mentioning that, you know, that person has to rely on other inmates to push them around, and you know, so whatever may be your reasons, you will find your exceptional reasons and you'll have to put them forward.
Question.
Yes.
Exceptional circumstances, are they only medical or they can also be economical?
Economical, how? To say he's gonna lose their job?
Not that only, maybe other factors that can play in, like if
they're running a business, the shop is gonna close down.
Sorry?
If they're running a shop, maybe the shop is gonna close down.
Yeah, also that. Because
but is it exceptional? Because now they'll balance it. Remember, here we're dealing with Schedule 6 offenses. I told you, it's very serious offenses of your armed robberies and, you know.
Yes, isn't it the person is accused?
Hijackings, your gang rape, you know, serious cases, murder, you know. Yeah. Sorry?
So they are only medical?
No, it can be anything that you can show that it carries a heavy, you know, impact that it will have, and it will be something that the court cannot just lightly consider to be one of the factors. It's a very heavy factor for the court to disregard in granting or not granting bail. So it should somehow press the court that I think it's better for me to grant this bail. So like that's why I was making the more common one of medical issues, because we know the limitations that the correctional services have. And please forgive me because my brains are fried now. I can't think. There's lots of examples, ladies and gentlemen. It's just that my brains are fried now. I can't think too much. So
Elsie?
yes.
Can I pass in? What about a pregnant woman? Medical reasons, a pregnant woman or a woman with a just newborn baby. What about those? Are those exceptional, treated exceptionally?
The prison has a hospital section. Women give birth in prison every day. Children are born in prison every day. They are raised in prison. They even have schools for those offenders' children. Crèche is there for the offenders' children. So the facilities, they cater for that kind of situation. Unfortunately or fortunately, depends on whose side you are on. So like, for instance, the example you are giving of a woman who's pregnant, this woman has just killed her husband. And it may actually, the state may be saying it was premeditated. So it's not going to be just an issue for the court to just hear and release. So the court has to seriously consider. So, yeah. I'm sorry to have led you to think only on medical terms, but it's because I'm tired now. So, but yeah, if you know you have other reasons that brain freeze, yes.
Spiritual reasons.
There's lots of reasons, believe you me. We state them when we are trying to persuade the court to see that there is exceptional circumstances. Yes.
Yes.
So, yeah, that's just look, one of the major factors that I know in terms of case law has been found to be a very persuasive factor. It's the strength of the state case. You know, where you would say that the state doesn't really have a strong case, even though the case that is before the court is one of those considered very serious ones. But if you somehow probe into the kind of quality of evidence that they will be presenting, if you are privy to it, then you will say the evidence that they have will not lead to a conviction. So it's one of the exceptional circumstances. Okay. Okay. So please, this one, it applies to all the offenses. Whenever an accused appears before the court at the first appearance, they are compelled to inform the court of any previous convictions or any pending cases that they have, and whether they've been released on bail or not. Failure to do so can lead to them being found guilty and given a fine for not disclosing that information to the court. And one last thing.
You are no longer audible, ma'am.
We can't hear you anymore, Elsie.
Muted, Elsie.
Can you hear me? Can you hear me? Can you hear me?
Yes, now we can hear you.
Okay. I see that
Yeah,
at
now
least my
you
no, we just had load shedding, so I forgot actually that it's coming on at 8. So I was supposed to set up my device that I can be on another network, but seemingly I don't even know which one we are using now. But yeah, we can finish the class at least. So I've mentioned this, that whatever that is being said at the bail proceedings will form part of the trial record. So whatever that the accused says, if it's going to be something that they can use against them at the trial, it can be called and it can be produced at the trial. You can't prevent it. So it is good to also warn your client, like I was saying, not to lie about their pending cases, their previous convictions, and also that the statements that they make at the bail proceedings, they shouldn't change when they get to trial, because prosecutors, they do tend to call for those bail proceedings and they confront the accused about them. And it now shows that the accused cannot be relied upon. He's someone who lies. So the court obviously has a duty to warn the accused that anything that they will say there can be used as evidence against them. But even if the court talks, you as the legal representative still have to ensure that you have made your client to be fully aware that it's an issue. Now, when we, okay, are we having any questions? I don't know, I seem to be rushing through this now. Are we okay with all the factors that
I
I've
just have
mentioned?
one question for clarity. I just have one question for clarity. On the previous slide, you mentioned that should they not declare their previous convictions and they will be charged, so they will be found guilty. So will they found guilty for lying or contempt, or whatever the case may be, or what is it that they'll be found guilty of? Is it the charge now at hand, or what is it exactly?
Hello, can you hear me now?
We had lost
Hello?
you again. I'm not sure.
Yeah, no,
I'm not sure if you heard
we are
my
safe.
question.
I'm back to the house Wi-Fi now. Sorry about that.
Did you hear my question, Elsie?
No, I didn't, because there was a changeover from the internet. But can you repeat yourself
if you
again?
go back to the previous slide, If you go back to the previous slide, the last bullet point, you mentioned that should they
This
not
one?
inform the court of the they'll be found guilty. Yes. You say that they'll be found guilty. I just want to know which charge will they be found guilty of, the current charge or some sort of lying to the court or contempt or whatever it is.
It's contained in the. There's even a penalty that is. It's contained in the provisions of the Criminal Procedure Act. Just that I can't remember the section.
Okay.
But whenever every accused
That's
person
fine.
appears,
I'll find it.
yes. So the penalty is normally that they will pay an amount of like 300 rand or up to 6 months imprisonment for failure to disclose that information. So
Okay,
it's a
thank you.
penal. It's a penal clause. It's a penal clause. Yeah.
Ma'am?
So yes.
Ma'am?
Yes, we can hear you.
Yes, ma'am. Yes, basically, what that section says, it says the person can be sentenced up to 2 years or a penalty of 120,000 rands. Then
Depends.
what the prosecutor, pardon?
Where are you? Because here I'm in the district court. Now, if you are going higher, you are that kind of sentence it's in the regional court.
Yeah, it says up to
Okay.
120
Mm-hmm.
or 2 years imprisonment. I know that magistrates would give you a lesser amount, but there's a separate annexure or the charge that you need to add for failing to disclose previous convictions or pending cases. So
Yeah.
it's up to 2 years or 120, up to
Yeah.
120.
Yeah, but our colleague said she will find it, so I'm grateful for that.
Yes.
She will do us
Okay, thanks.
thank you for that.
Thanks, ma'am.
Yeah, but every accused person is warned before you even have to address it. So, but you just have to repeat it because I don't know, maybe they are too scared when they arrive in court that it misses them somehow, that they don't actually take particular note of this. And you always have to, I say, are you sure you don't have anything? Are you sure? And then only when you say, are you sure, you may actually get, actually, there was a time when I was like very young, and then how young were you? You know, man, I was very young, you know, so that's how it works. So, but it's better that it comes from you than when it comes from the court or from the state, then it looks bad.
Hello. Hello.
Someone is talking.
Yes. You know, I just found that you did something assault a long time ago, can't even remember, and you paid a fine maybe 50 rand 10 years ago, and then you find that you're applying for a job, and then it's coming on the police report that you were actually admitted. You did admit that you committed
Admission
a crime.
of guilt, you mean?
Yes, and then can that also be considered as that you were convicted and then you have forgotten about it, and this was just done when you were young, you forgot about it such a long time.
The point is that you were found guilty. Even with an admission of guilt, it's a finding of guilt, though it's not pronounced by the court, but it's tantamount to a judgment that is the effect is the same. It carries the same results that you are having a previous conviction. That is why it will show when you are looking for a job, unfortunately. But you know, we'll come to that part where we deal with that kind of a situation to reverse somehow that situation, not to have that impact. But it's better to disclose than when it's coming from the state, then it looks like you were hiding something, you know? Okay.
Elsie, I just have a quick question regarding contravening bail conditions. So let's say, for instance, one of the bail conditions is that this person has to report to the police station once a week, and they don't. What are the consequences of that? Do they get arrested again and put into custody, or do they forfeit the money that they paid for bail only?
Yes. Because if the prosecutor can become aware that through the police, obviously, that they are not complying with the bail conditions, then that docket will be brought and they will place that information to the magistrate who gave that information. And then the bail of that person, number one, is going to be cancelled. And then that money will eventually be forfeited. If they can come on their own to court, then maybe they can explain why they are not able to. The court will listen to their reasons. If they are unfounded, it can lead to that bail being cancelled. And at times, the court can refund back the money to the depositor because the person didn't run away. But yeah, it's better if there's a problem with a client complying with those conditions, that you immediately come forward and say, my client is not able to comply, because it's a serious violation of the conditions if they don't, without good reason, comply, because then the court is not going to be so sure that they will actually attend the case to the end. So the bail can be withdrawn if they are actually there in court.
Elsie, if I can maybe give an example that might or might not be relevant, because actually in this case, the person was a parolee. And what happened was he was sentenced to community service at the local, to go and clean at the local clinic. And what happened was the book where he used to sign stayed at the clinic. But now during one of the community protests, they burnt down the clinic, and obviously the book was inside. So when he then went to the police, he didn't have proof that he'd actually been serving his community service. So they actually rearrested him and he spent a further 4 years in jail.
And no one from that clinic could be called to testify to the effect that indeed he was not reporting to a book. He was reporting to maybe a station.
I don't know what happened in that case, because when we went to speak to because there was no clinic, the people were no longer there. But we did find one of the nurses who was working there and we gave her details to the police. But next thing we know, they just rearrested him and he went to jail for another 4 years. So I'm really not sure what the detail there was.
And also, the people who are on parole are supposed to be assigned what is known as a correctional officer. A correctional supervision officer who will be supervising their movements from time to time to ensure that they are not violating the parole conditions. So that could have been someone who would have assisted to help with maybe some information to confirm that indeed initially they had been going there. Or
yeah, maybe just to throw my thoughts on that, Madam Elsie. I think maybe the legal representative also did not do his or her job, because if we have that situation where a clinic gets bent down and there's evidence of that nature, for me, the legal practitioner ought to have made that information known to the court that this is what happened. So the conditions were not
deliberately, yeah.
Yes. So I think that would ought to have been the case. So maybe, yeah.
Yeah. No, but at least he's back home now, so that's fine. But
shame. A further 4 years is not easy. Eh? We are talking easy maybe because we've never been there. Being in jail is not nice. Even 2 days is too long. It's like 20 years.
Tracking system. They don't have tracking system that will track the whereabouts, whether this person is reporting now or not. Doesn't they have such a mechanism?
South Africa is not like America where they keep, those leg braces. In America, those people on parole will have something attached to their feet, their leg, so that if they're moving around, they are tracked, their movements are tracked. South Africa doesn't have those things. You see, it's too expensive. We are a third world country. We can't afford, even we are broke as a country. So You can't even. Yes. That's why we are in the dark now. Yes. Are we done with the questions on the bail conditions? Yeah, Mr. Van Rooyen, I feel your pain.
I just want to know, when it comes to bail conditions, in court, there are those people who are called assessors. Do they have influence in bail condition or bail whatever statement?
Bail assessors are involved in everything, right, that the presiding officer would want them to assist with. So most of them, first of all, they are not legal persons like us, like with law degrees. They are taken from the society, like the good citizens, who
like the school governing bodies.
Yes, so they don't have to have legal qualifications, but they would be called upon to assist. In the past, remember, most of the presiding officers were white, and they would preside in, like, for instance, black or colored or Indian areas. So they were not so much clued up about the lifestyle within those communities. So then they were now taken to come and assist the court to have an understanding of how people behave and what would lead them to do something that to someone of a different race, they will find that to be something appalling, that how can they, and then to the general community there, that is a common practice. So then those people, they will then assist the court. If the court, but I haven't actually seen them participating in bails. Most of them, they are like spectators, more where they are actually used to give inputs. It's when it's actually on trials, whereby they will, I'm talking here in the lower courts. My experience with the higher courts also, I would also believe that they are assisting with trials. So with bail applications, they will be there, but you would hardly get them to even asking any questions, or they will just be sitting there. Sometimes they just looking away. You don't even know whether are they listening or what. So really, your intention would not be to really address them. You focus on, the presiding officer. So I don't know whether maybe if the matter is adjourned for the court to consider judgment, then maybe the presiding officer will actually pick their brain on issues that are unclear to them. Then they can contribute their knowledge of things as they stand within those communities. You see. So assessors, then they don't give any legal opinions, obviously, to the court. It will just be more about lifestyle, to assist the court to understand that this is how people live in this area. And actually, it may actually not be good, man, for them to be involved in your case, because they are also carrying some biases, because they are just ordinary persons on the street who may, not have an expanded knowledge that a legal person would have. So, but if it's just to assist the court to understand basic things, yes, they may be helpful, but they can also be bad. I remember earlier in my years when I was working in one of the big townships, that magistrate used to like using those assessors, and it used to be quite frustrating because you would have your own strategy dealing with the case, and you would see that the court is following your line of thought and is seeing where you are going with the case. And maybe the court adjourns for lunch. When the court comes back after lunch, you can see the face is not yellow anymore. It's looking a bit gray. because they do discuss things that are behind closed doors and you don't know what is being said, you know. So I wasn't really particularly favoring them personally. That's me. Yeah. Okay, so those conditions, yes, they are there, and then we do our best to try not to violate them. But even as they are being granted by the court, they should be within what it would be practically feasible for the accused to comply. So yes, you can ask for the relaxing of the bail conditions, and it may irritate the presiding officer, but if you have good reasons for asking, I've seen it many times, they do actually relax them and grant the conditions that your client will actually be able to comply with, because that is the idea, that they must comply. So if they put conditions that they can't comply with, then it becomes a challenge. So I think this is almost the last slide. There's what is called a head of prison bail. This is a bail that is in terms of section 63, capital A of the criminal procedure, which grants certain powers to the head of prisons to identify within the criminal population of awaiting prisoners, awaiting trial prisoners. They are going to identify people who are going to be eligible for them to be released on either bail or on warning. So the head of prison must be satisfied that, for instance, they find, and this is common here in South Africa, that the prison population is reaching such proportions that it will constitute a material or an immediate threat to human dignity, physical health, or safety of the accused persons in their custody. So here we are talking about overcrowding, for example, and maybe an outbreak of a medical issue, like a disease that can lead to, or maybe it's one of the communicable, what do they call them? Communicable diseases, like with COVID. I know that some head of prisons used this section to release some people these people are people who are charged with less serious offenses. So it's not very serious offenses like your murders, your rapes, and whatever. Like it's those like shoplifting and things that are not hectic, that the head of the prison will be able to, yeah. Or if it's someone that, for instance, the court has fixed a bail amount maybe of 500 rand for a minor offense, of course, but this person has been sitting for 8 months to maybe a year, they're not able to raise that 500 rand to pay the bail. So if they can be brought to the attention of the head of the prison, then maybe they may see that they qualify as indigent and actually release them with a warning that, please remember the court has given you your next court date. Just make sure that you actually go and appear. So section 49G, it's one that is from the Correctional Services Amendment Act. This one is dealing with those accused persons who are awaiting trial in custody for 2 years or longer, where their bail has been refused, and then it requires that they should be brought to court. Through an inquiry, the court should determine whether they should continue to be incarcerated. So this section 49G can be applied for when even either the trial hasn't started, or even if it's in the middle, the trial has actually started. So what you would do there, you would actually now argue before this inquiring court that, look, the state has presented this evidence so far, and from the evidence presented up to now, they have not been able to make out a strong case. So things are looking shaky for the state that they might not actually secure a conviction. And on those grounds, the court should consider releasing the accused on bail. Okay, last one. Now, when you have a situation where...
Kelsey, can I just interject with regard to the previous slide?
Yes.
This form of bail, can it be initiated by the defense?
Yes. You can bring that is going to be through either you requisitioning this person to be brought, or when they actually come to court, then for whatever, maybe it's still investigations waiting for DNA or whatever that is happening, that the trial is still ongoing. So you'll have to choose a separate date if the trial is ongoing. Choose a separate date when this accused must be brought to come and deal with this inquiries. So it can be at the instance of the defense and also through the state. It can be done through the state as well. Now your bail, as I said, it can be granted or it can be refused. If your bail is refused, unfortunately, okay, granted, let's say it's granted, we are all happy, we are jubilating, and we hope that even the trial, you will win there. But sometimes we know it doesn't happen, so the bail is refused. In the same court that has refused your bail, you happen to get into the record and you get information that you would like to bring to the attention of the court. You can, in the same court, bring another bail application, and you will now be basing this on what is called a new facts. This is common to be abused because I think maybe our lawyers are not clearly understanding how this is supposed to be used, or because maybe of trying to, you know, I don't know, I don't want to say desperation, but maybe because, you know, some find it difficult to turn away clients and tell them that, man, I can't find anything here. So they would still bring this bail on new facts, and it becomes quite irritating to the presiding officer if you are coming to repeat what has already been said in the initial bail application. So if you are doing this second bail application before the same court, it has to be new information that was not presented before the bail hearing. And it has to also be something that you can justify to the court why that information was not informed to the court previously. So you can't just come and repeat what was already said. And if you do, then they won't even waste time with you. They'll just tell you bail is still refused without even giving much reasons. But if you come with very new and very convincing information, then it will change the perception of the court now, and they may actually grant you that bail. Now, if the bail was done and it was refused, and you actually don't have new facts, but you are of the view that from that first bail application, there's, you know, a possibility that a different court hearing that bail application could reach a different conclusion, then you take the matter up on appeal. So with a bail appeal, you don't follow the process of putting a notice to say we are intending to go to the High Court and present your grounds for the appeal, for the bail. You just proceed to the High Court, approach the registrar, and that appeal will be permitted there at the High Court. Then you address the reasons for the refusal. And also maybe you can challenge also maybe the amount that the court has fixed, or even the bail conditions. So this one is something that is also very popular, and the success rate of bails that have been refused when they actually do go to high court is very high. Success rate in the high court is very high. So many times where the lower courts have refused bail, you know, the judges, they grant those bails. So it may be more costly for the client, but it's actually highly encouraged that take them on and go to high court and appeal. I mean, for instance, there's cases where a court has placed an exorbitant amount that was being fixed for bail, and the high court can even say, pay 50 rand and go home. So you will be surprised that the high court's approach is entirely different from the lower court's presiding officers. Attitude is completely different in the high court. When they approach bail, they take it very, very serious. Like, I don't know, like maybe there's something else that they've been told there, but yeah, they really do. I don't know, but yeah, please, I can't say this enough. When your bail is refused, go if you can afford it, or go and appeal in the high court. Success rate is very high. So you may need obviously then to know when you need to bring an appeal for a bail, or if it's a bail based on new facts, then that's case of State versus Peterson. It's a very nice case that sets out that distinction for you. And please visit it, read it at your own leisure, ladies and gentlemen. We are 6 minutes beyond our time. I don't think we have questions, and I think we can close our session here.
Thank you very much. Goodbye. Bye-bye.
Thank you,
Access
Elsie.
madam.
Thank you, much appreciated.
Thank you.
Bye, guys.
Bye.
Thank you,
Thank
Professor
you,
Thank you,
Koza.
Elsie. Enjoy your evening.
You too, guys. Bye.
Good. Unfortunately, we missed State of the Nation address.
But anyone knows, guys, how to access these meetings, this presentation, as we had load shedding now and again?
Yes, you can go to the what's it called, the notification or something. Or you look
announcement.
Announcement, yes, on announcement.
Yes.
Yeah, you will find them. They usually post them there.
The general announcements, or I mean for this, or for each and every module. Okay, all right.
Yes.
On the site portal. Okay, thank you.
Yeah. The other one, don't worry about the State of the Nation. There's nothing new that came from the president.
Malema did say they will destroy.